Assalamualaikum warahmatullahi wabarakatuh. I am Munira from Group 8. As an overview, negligence is relating to tort, vicarious liability, defenses, and also the elements of negligence itself. Don have always wanted to buy his dream classic car, a Mercedes-Benz, but does not have enough money. Recently, Don received a windfall which enabled him to purchase such car. He consulted Nobita, a classic car specialist, to get his opinion on the intended to purchase the car. The selling price was 31,000 ringgit. After meticulously checking over the car, Nobita told Don that the estimated value should be not less than 30,000 ringgit. Believing the car to be of such value, Don proceeded to purchase the car. However, he later discovered that the actual value was only 10,000 ringgit. Don decided to go and see Nobita to express his dissatisfaction. While driving to Nobita's house with his wife, Ray, they met with an accident caused by Nobita's negligence in maintaining a private bridge leading to the house. Ray died on the spot, but Don did not suffer any damage. However, the car was a complete wreck. A television crew who happened to be there at the time of the accident caught the incident and telecasted it live over the local TV network. It was witnessed by Mon, the daughter of Don and Ray. Even though Mon did not see her mother's body, she suffered a severe shock that led to her becoming insane. Advised Nobita of his liability towards Don, Ray, and Mon. In the first issue, whether Nobita is liable for negligence towards Don. As in general, negligence is a breach of legal duty to take care that cause damage to the claimant. There are three elements to prove negligence. One of the elements is duty of care. Duty of care means the duty imposed by the law that requires a person to conform to a certain standard of conduct. The question is to whom the duty is owed. It is by the neighborhood principle. Who is our neighbor? Our neighbor is the person who is directly affected by the act of the person who owes the duty of care. For example, in the case of Donohue and Stevenson, the plaintiff suffered damage after he consumed the ginger beer that was manufactured by this one company. The court held that the defendant, the manufacturer, owes duty of care towards the plaintiff as he, as the manufacturer, should provide good quality of product to sell to his customers.
Now, in order to determine whether a defendant owed a duty of care towards the plaintiff, the court used the Caparo test. There are three stages in the Caparo test. The first stage is the possibility that the defendant's carelessness could cause damage to the claimant. The second stage is the proximity relationship between the defendant and the plaintiff. And lastly is it fair, just, and reasonable to impose a duty of care on the defendant to the plaintiff.
Now, the application. It was proved that Nobita was indeed had owed duty of care towards Don. This is because it has fulfilled the criteria of the Caparo test. First, trusted seller and customer relationship exists. Second, it is foreseeable that Don will rely on Nobita's advice without any doubt. Third, it is fair, just, and reasonable to impose duty of care towards Nobita. The meaning of breach of duty of care. The defendant who owes a duty of care towards the plaintiff had acted below the minimum standard of care required by him and caused the plaintiff to suffer harm.
To measure the standard of care, the reasonable man test was used. In this test, if the defendant had acted below the standard of a reasonable man, the law says that he had breached his duty of care towards the plaintiff. Here, we are focusing on the defendant who expertise in the particular field, which the reasonable man is expected to be someone possessing the same knowledge and expertise as of the defendant. The case that can be referred is Wiltshire and Essex Area Health Authority.
Next, negligent misstatement. The definition given was inaccurate statement made honestly but carelessly, usually in the form of advice given by a party with a special skill or knowledge to a party that doesn't possess this skill or knowledge. There are 4 conditions that must be fulfilled. First, special relationship must exist between the parties. Second, the defendant must realize that the plaintiff intends to act based on the information given. Third, there must be reliance on the advice by the defendant. And lastly, the reliance on the advice must be reasonable and foreseeable. The application that proved Nobita had breached his duty of care as a reliable car specialist consultant. Why? First, Nobita acted below standard of reasonable man when he was not updated with the Mercedes car's value in the current market price. Second, it was proof that all the conditions of negligent misstatement has been fulfilled. Lastly, due to Nobita's advice, Don had spent money 3 times from the actual price, which is Rm30,000 instead of Rm10,000.
The third element of negligence is damages. Damages is the loss caused by one person to another or to his property either by intent to harm him, neglect and carelessness, or by unavoidable carelessness. The test to be used to determine damages is Part 4 test. The test asks but for the existence of defendant's breach of duty, would the damage suffered by the plaintiff have occurred? If the answer is yes, then the defendant's breach of duty did not cause damage to the plaintiff, while if the answer is no, the defendant's breach had caused damage to the plaintiff. This can be proven in the case of Burnett against Chelsea and Kensington Hospital Management Committee, and the case of Goodyear Tire and Rubber Company against Leroy Higa. In this situation, Don had suffered damage in terms of property by wasting his own money in purchasing the car that suggested by Nobita at a very high price. Nobita's negligent conduct has caused Don to suffer massive loss for 20,000 ringgit. In conclusion, Nobita is liable for negligence towards Don. For the second issue, it is between Nobita and Ray, where Ray died due to the accident when the bridge fell in front of the Nobita's house. This can be referred under negligence and can be referred into the case Blights against Birmingham Waterworks Co. For the property refers to the legally protected claim to resources such as land and personal property, including intellectual property. Property can be exchanged through contract law, and if property is violated, one could sue under tort law to protect it. The owner of the property have a duty of care towards the public when the public use their own property.
Next element is breach of duty of care. There is Nobita, Ray, which is Don's wife, and then Don. Now we're going to describe about Don and Ray. They are husband and wife. Ray died cause of the accident and their case was applied res ipsa loquitur. Then Nobita, he breach of duty of care. He is liable for negligence and he owes duty of care towards Don and Ray. The conclusion is Don can sue Nobita under negligence that caused his wife die. Next, we'll move to the third issue, which is between Nobita and Mon. The issue is whether Nobita is liable for the psychiatric harm towards Mon. There are classification of psychiatric illness, which is mental illness, neurosis, and personality change.
After my test, the issue was whether the nervous shock was reasonably foreseeable in the circumstances. In this issue, foreseeability of harm alone is not sufficient to establish duty of care. Establish duty of care. Firstly, the person who claimed that must have the close emotional relationship with the primary victim. Secondly, there must be physical proximity of the accidents in terms of time and also space. This means that the plaintiff who did not actually see the accident at that time, but that person see the immediate aftermath of the accident. The shock that caused by the plaintiff seeing and hearing the accident that caused upon the immediate aftermath. Lastly, the psychiatric condition is medically recognized. This can be proved in the case of Alcock and Chief Constable of South Yorkshire.
Now, moving on to the requirements for claim of nervous shock. Firstly, it is reasonably foreseeable that plaintiff will sustain psychiatric illness due to his close relationship of love and affection with the primary victim. Secondly, there must be physical proximity between plaintiff and the victim in terms of time and space. Lastly, the shock must be caused by actual sight or sound of the accident or immediate aftermath. Next, primary and secondary victim. Primary victim is the one who suffers physical injury and psychiatric injury as a result of defendant's negligence. For secondary victim is the one who only suffer psychiatric injury. So according to Alcock and McLaughlin, secondary victim must prove the immediate aftermath test.
Now is the application for Nobita and Mon. This is Mon, the daughter of Ray, and this is Ray, the mother of Mon. This is Nobita, the car specialist. So Nobita is liable for the psychiatric harm towards Mon because Mon suffered severe shock that led to becoming insane. Because there is presumption due to closeness, love and affection that involves parent and child relationship. The severe shock that led Mon to becoming insane was reasonably foreseeable because Mon was watching the accident of Ray live on the local TV network. Therefore, Nobita has a duty of care towards Mon since Mon has a close emotional relationship with the primary victim, because Ray comes within the scope of the duty of care on the part of Nobita. Moreover, there is physical proximity to the accident that happened whereby Mon did not actually see the accident but sees the immediate aftermath of it during live on local TV network. The severe shock that led Mon becoming insane is caused by the result of Mon seeing her mother died that comes upon the immediate aftermath of the damage because of her watching it live on TV. The psychiatric condition that Mon suffered is medically recognized. Therefore, Mon can be declared as a secondary victim because she is the one who only suffered psychiatric injury, which is severe shock that led to becoming insane. Mon, as the secondary victim, has already proved the immediate aftermath. In conclusion, Nobita is liable for the psychiatric harm towards Mon.
Now, we have presented all the three issues that we discovered in the question. That is all from us. Thank you.